Hi, TikTok, join in, share the live video as soon as you get in. We're about to get started with this very important discussion. Today, we're going to be talking about something happening in immigration court. So join in and share the live feed, share the video to your family and friends who may need to hear what we're about to say. Hello, everyone. Very excited to be back your way. Today we have a very exciting topic as usual. If you guys can see me and hear me, please drop USA in the comment section. USA, just type in USA. Let me make sure you can all see me and hear me. And I'm going to wait for feedback from viewers on Instagram, YouTube, LinkedIn, Facebook, TikTok. Just type in USA, or you can just drop an emoji of the US flag. And then I will be aware that you can hear me and see me well. Type in USA if you can hear me and see me across the platforms. And then we can get started as soon as possible. All right, guys, very excited to be here. Today, we're going to be talking about a new immigration court memo that was released, and that is telling immigration judges, giving them the power to pre-termit or to deny asylum applications in court if the application looks like it's legally deficient. So we're going to be reviewing that memo, and then we'll look at what that means for you and what you need to be doing. And we'll talk a little bit more about immigration interviews. Hopefully we can do all that in today's live video. Please stick with us. And if you can hear us, drop USA in the chat section. All right, guys. So let me go ahead and share my screen with the people on Facebook, LinkedIn, and YouTube. That's where we're sharing the screen. If you want to look at the memo that we're reviewing, feel free to join on those platforms. Okay. All right. Let's see here. Let me increase the. Okay, there you go. So this memo was released on April 11, 2025. The date on which the alien registration rule went into effect, where all non-citizens are supposed to register the same date. A lot of things happened on that date. So it was released on April 11, 2025, and it was released by the director of EOIR, Cyrus Owen. That's an acting director of EOIR. EOIR is the Executive Office of Immigration Review, and that is the federal agency that manages all the U.S. immigration courts in the United States. So when you hear EOIR, it means it's talking about immigration court system. Okay, so immigration court. And the memo that was released is called Pre-Termination of Legally Insufficient Applications for Asylum. We're just going to look at a couple parts of this, and then we can go into what is asylum, what are you required to prove, and then we can look at a couple of case laws. We look at a couple things, and then we can take questions. So stick with us, and we'll be taking questions very soon. All right. So it says that EOIR adjudicators, that's immigration judges, they have a duty to efficiently manage their dockets. Their docket is obviously how many the cases they have pending. It is clear from almost 4 million pending cases on EOIR's docket that has not been happening. If you guys are following our social media platforms, we posted about 2 days ago about the fact that there are actually about almost 4 million pending cases in immigration courts. The backlog is historic. This is the highest in US history ever. 4 million cases. It's just monumental. I believe 2 years ago it was just under 2 million, and now we're almost at 4 million. The US has never seen this number, historic number of backlog in US immigration court history. So there's almost 4 million pending cases. About 2 million of them are asylum applications, and which is why they released this memo, because they want the judges to just quickly deny or just close out applications, filed asylum applications where it looks like there is no legal basis, according to the memo. Okay, so it says that because of the 4 million cases, they have to find strategies to just clean out these cases. Okay, now it goes on to say in the memo that aliens or non-citizens in removal proceedings, they have the burden to show that they are eligible for any type of relief or protection from deportation or protection from removal. And so, according to the memo, if you don't show an initial eligibility, if on the face of it, they cannot tell that you qualify for asylum, or you qualify to get a green card, or you qualify for something called cancellation of removal, then they should close out your case or pre-terminate your case. Okay. The memo referred to a case law called matter of Fifife or Fifife. That's actually a Haitian name. It's a Haitian name. So matter of Fifi or Fifife, whatever, however that is pronounced. The memo is claiming that case law is not in effect anymore. It also cites a case law called matter of EFHL, stating that it's no longer in effect. We're going to look at all this and then see how this could affect you. Okay, so the memo is saying that if there is a legally deficient asylum, and which could be that you haven't properly shown that you are eligible for asylum on the face of your application, and there's no factual issue in dispute, then they are not required, or the immigration judges are not required to hear you out in immigration court. And so your case should be closed out. Now, let me now go to what is an asylum application. First of all, an asylum application, because you've suffered past persecution, if you are somebody who has suffered past persecution, or you have a well-founded fear of future persecution, then you could be eligible for asylum if you are inside the United States. If you are outside the United States trying to apply from outside, then it's a refugee process. If you are inside, it's asylum. In addition to showing that you have past persecution, or you are afraid of, there's reasonable or well-founded fear of future persecution, you have to show that the fear of persecution is based on race, your religion, your nationality, belonging to a particular social group, or you have a political opinion. So based on if you are Black or you're white, or based on your religion, maybe because you're Christian, your home country government wants to persecute you, or an actor that your home country government is unable to control. Okay, so if you do qualify for asylum, or you speak with an attorney, or you find that you feel like you qualify for asylum, you would usually have to file the asylum application, the form I-589, within 1 year of arriving in the United States. And then if your case is approved, you can work in the US and you can help family members seek asylum. Then you can also apply for permanent residency after 1 year of being granted asylee status. Okay. Now let's jump to, let me see here if there's anything else we need to talk about Yeah. Okay. They cite some case laws and say that based on these case laws, if there is not a legally sufficient reason, then an application is subject to pre-termination, denial, before being heard, before a full and fair evidentiary hearing. Because the typical process is that, let me go back a little bit and say that there are two types of applying for asylum. There's affirmative and then there's defensive asylum. Affirmative asylum, you come in lawfully into the United States, and then once you arrive in, let's say you are a student or you come in on a B2 visa, you apply for your asylum and you file it affirmatively to USCIS. This is the non-adversarial proceedings, and USCIS will adjudicate your application. On the other hand, if you came in through the border without being inspected and admitted or paroled, you didn't come in with a visa, you entered unlawfully, for example, then you can be sent to immigration court. Your asylum application will be filed or should be filed in immigration court. It becomes a defensive asylum application because now you are subject to removal and you have to defend yourself. Affirmative, you came in lawfully, so that's fine, but you're still trying to claim asylum. Okay, so once your case gets to court, that's when the judges, the memo is saying, pre-terminate or just close out all these cases which look like it's legally deficient. All right. Okay, now let's jump to so that we can have time for questions. Let's jump to another document here. Let me see. Okay, we're going to look at one case law, which is still in effect, which shows that there must be evidentiary hearing, okay, matter of Fifife. Let me just go with Fifife, okay. Okay, let's go with matter of Fifife, F-E-F-E. So this case was decided by the BIA quite a long time ago. And the case is about, as I mentioned to you, a Haitian, I'm not sure why my screen is not moving. Okay, it's about a Haitian person who was placed in removal proceedings, and his case was ultimately denied, and the BIA, it was denied, and then he appealed to the BIA, and the BIA gave a ruling. And in the ruling, the BIA stated that an applicant for asylum cannot meet his burden of proof. If you remember, every case you're filing for anything in court has a burden of proof. If you are applying for something in court or you are defending yourself in court, there's a burden of proof. Either the prosecution is the one that will bear the burden, or the defendant will bear the burden. If it's immigration, you, the applicant, you could bear the burden. It could be the government that bears the burden. The burden can shift from the applicant to the government. So in this case, the applicant, you are the one asking the government to grant you asylum. So the burden of proof is on you to show that you should be granted asylum or that you are eligible for asylum. So if an applicant for asylum cannot meet his burden of proof, so the BIA decided that an applicant for asylum is unable to meet his burden of proof unless he testifies under oath, okay, regarding his application. So until you take the stage, so to speak, you mount the stage and then speak about your case, then the applicant has not yet met his burden. So he should be allowed to speak about his case. The case also said that, therefore, an immigration judge should not proceed to adjudicate a written application for asylum if no oral testimony has been written in support of that application. in order for the judge to give a written decision, then, okay, I think, oh my gosh. Yeah, I'm struggling to share the screen. It's not, it's just goes in and out. Let me do that again. Let me see if I can do this again. It just keeps going in and out. Okay, well, let's go on. Let's go on without it. Unfortunately, let me see. Let me just pull it up here, and then I may not share it, but oh no. Hmm. Okay. Oh, okay. I see it now. Okay. I think this works. Let's see. Let me share my screen again. It went off. Let's share it. There you go. All right. So the applicant was a 24-year-old citizen of Haiti, and he came to the US in November 1988. And they started exclusion proceedings. That's in the past what deportation or removal proceedings were. And he was issued with a notice to applicants for admission detained for hearing before an immigration judge. All right, he was issued with this notice, and they alleged that he was inadmissible at the hearing, at his exclusion or deportation hearing. He didn't contest the fact that he was deportable. Okay, and the applicant's attorney or lawyer told the judge that they were going to rest on the record because the client's story, the asylum story, was very extensive, and so we'll just rest on that. That's what the lawyer told the judge. The judge also didn't ask the applicant any question, and then in the end, the guy's application was denied. This Haitian gentleman, 24-year-old. And then this guy goes to see another lawyer, and guess what the new lawyer does? The new lawyer actually stated that the applicant received an ineffective assistance of counsel. That's a claim that you make against your immigration lawyer if your case doesn't go well and your lawyer should have done something substantial and didn't do it, or something that could have changed the outcome of your case and didn't do it. So they said there was ineffective assistance of counsel, and that there should have been, the gentleman should have been allowed to testify, because the law says that there's no way that he's able to meet his burden if he doesn't testify about his own case. So the BIA held that it was very important that the applicants for an asylum application or in removal proceedings, they should be examined. There should be a full examination of an applicant, because that's an essential or very important part of asylum adjudication. And you know why? It doesn't only cover Fifth Amendment rights, right? Because the US Constitution guarantees that there's a Fifth Amendment right to due process, meaning you are entitled to a full evidentiary hearing before an immigration judge. But the BIA also said something that is very instructive and very helpful. What they said was that sometimes there's a significant difference or discrepancies or even meaningful omissions between what the applicant will write and submit to court, and when they take the stage, or they mount the witness box, what they are saying is totally different. And so not only does it give the applicant the opportunity to clarify his case, but also it allows the immigration judge to see who's lying and who's not. Some people are not able to withstand the pressure when they are on the, in the witness box. If they lie on paper, once they mount that witness box and then they start going through direct examination, they go through cross-examination by DHS, they will crumble. And so BIA said that that's when it's during the full examination of the applicant that asylum claims that are fabricated can be outed. That's when they'll see that this looks like it's a fabricated claim. Because if you follow just what somebody has written, you might be convinced without doing more. Okay. So it says, if an applicant is not fully examined under oath, there would seldom be a means of detecting unfortunate instances in which an asylum claim is fabricated. On the other hand, there are cases where an alien establishes eligibility for asylum by means of his oral testimony when such eligibility would not have been established by the document alone. So in addition to finding the fake claims, giving an oral testimony in immigration court could help people who really have a claim but couldn't show that they do have a claim on paper. So it goes both ways. So that's what the matter of Fifife decided. Now the pre-termination memo is saying, oh, just deny applications if it's legally deficient. And this case law says no, because you have to allow the applicants to mount the witness box and tell us about the application, because it complies with due process under U.S. immigration, under law. It's not even just U.S. immigration law, under law. And it also allows us to catch the people who are lying about their asylum. So it goes both ways. Okay. We're already running out of time. So let me see if I can share another screen here. Now let's look at least one statute. Let me see if it's this one here. Okay, there you go. Regulations. Okay. All right. So if you look at these regulations, let me pull up the name of the section under law under which these regulations are found. It's 8 CFR section 1240 11C3. So it says applications for asylum and withholding of removal. If you go to 3.3, it says that during the removal hearing, the alien shall be examined under oath on his or her application and may present evidence and witnesses in his or her own behalf. This is applying to asylum applications, or this regulation talks about asylum applications and people who are applying for withholding of removal. And it says that whenever a statute says shall, it means that it's mandatory, meaning the judge or whoever is supposed to do whatever I think it has to do, it's compulsory. There's no way out. It's not permissive, right? So it says the alien shall be examined during a removal hearing. The alien shall be examined under oath on his or her application. The law does not say the alien may be examined or the non-citizen may be examined. It says he shall be examined. This means that the non-citizen has to testify under oath. And if you look at some case laws, it says that even if the non-citizen has nothing to say, then the judge should still let the non-citizen or the alien get into the witness box and answer under oath. Do you agree, or everything you've submitted, you swear that is the truth? Even that confirmation alone can be helpful to satisfy the burden if that's what they want. That's how they want to go. But they shall be examined under oath. And then it says that they may present evidence. So you are not required to present evidence. Evidence can still support your case, can help your case, but it's up to you if you want to present evidence or not. But you shall be examined under oath by an immigration judge. Okay, so in court. And then it goes on to say DHS counsel may call witnesses and present evidence for the record. So under the fact that the same section of law under section 3.4 DHS counsel, that's the government counsel or the government lawyer, they may call witnesses, meaning it's not compulsory. But as for you, the applicant applying for asylum, you shall be examined. So the regulations make it clear that examination is mandatory for these removal hearings, especially asylum application, as I've shown you right there. Okay. Let me see if we have some questions today. I have to hop up early. And so let me just go to questions and then let's see if we have some questions, we can answer them. Tom V's53 says, how long does it take for asylum to be granted? It depends. It depends if it's affirmative or defensive. For affirmative applications, USCIS came out a couple of years ago and said they were doing the LIFO, last in, first out. So what they do is that if you come into the US today, or let's say last week, and you submit your asylum application to USCIS, they will review your case first and call you for an interview within less than 180 days. You know why they decided to do last in, first out? The people who submit the applications last, they'll be called first for interview. If you submitted your application in 2013, 2016, they will call you last. And the reason they do this is because people were coming in and applying for applications for asylum when they did not really have a basis for applying for asylum. So they were filing what's called frivolous asylum applications. And they were doing that to be able to get work permits, because when you apply for asylum, you get a work permit to be able to work. And people were aware that, oh, when you apply for asylum, it can take 10 years, 12 years. So, well, I'll take the work permit. I'll apply for asylum. I don't really have a basis. I'm not being persecuted, but I'll apply for asylum. I get a work permit. I'll start working in a nice big job, maybe Amazon, Facebook, at a law firm, in a hospital, in a school. I'll make a lot of money within 10 years. And then even if my asylum application is denied, I'll leave. So the government said, oh, okay, that's your plan. This is our plan. If you apply, we'll adjudicate your case first to prevent people from just filing these fake applications. Because when you apply for asylum, usually you have to wait 180 days before you can be issued with a work permit. You can submit your work permit application after 150 days of submitting your application, and then it could be granted only after 180 days of the pending application. So it was a plan by the government to make sure that people were disincentivized from filing fake or frivolous asylum applications. All right, let's see here. If there are no more questions, then what I'm likely going to do would be to share. Let me share another screen. I'm going to show you guys how the government does its interviews, USCIS interviews. And these are some of the things that we use to prepare our clients. Let me see. Okay, there you go. I found it. Let's see here. All right, there you go. I want to go to page 44. Let's see. So this, we have here the, training manual, just a part of the training manual issued by USCIS, the USCIS RAIO Directorate, to train USCIS officers on how to interview people, who have cases pending. Okay, so I don't know if you guys can see my screen. Now, here is the basic information that an officer needs to elicit during the interview. Number one, who is the applicant? If you go for an interview, this is how officers have been trained to ask the questions. So we're using that training manual. Who is the applicant? The officer is going to find out who you are. They'll find out how and when did you leave your country of nationality or last habitual residence. Why did the applicant leave his or her country? Did you come in on a B2 visa? Did you come in on an F1? or an L1, H1B, did you ever return? Are you afraid to return? If so, why? You know, the officers that have been trained to focus not only on the experiences of the applicants, but also on the experiences of others who are similarly situated. Then the officer will find out whether you are eligible under any of the grounds for asylum. Okay. Now, when it comes to things like the I-130 or the I-130s, which are typically petitions for, or just always petitions for alien relatives, you are filing for a family member. Then they will do the I-130 interview when generally the bona fides of the relationship are in question. What does it mean? If you've applied for your mother or your husband and they don't believe that that's truly that family member you've applied for, then they'll conduct an I-130 interview. And now the update is that USCIS is actually referring to immigration court people who have I-130s with USCIS and who go for immigration interviews. So make sure before you go for your interview, you came in unlawfully, you speak with an attorney before attending the interview. If possible, allow the petitioner to go alone for the interview and then be on standby. If they want to verify anything by phone call, by video, usually by video, they don't allow that, but by phone call, then you should be available to do that. Let me just jump to this part. Maybe we'll do another live video where I'll share some more about these interviews. Let me go here. Now, when it comes to asylum applications specifically, these are some of the questions that the officer should elicit from you if you're an asylum applicant. Number one, who is the applicant? Number two, who are the family members who are included in the application? How and when did you enter the United States? Why did you leave your country? Did you suffer past persecution? The officer will, focus on past harm or threats. If there are any threats, do you fear future persecution? What are the motives of the past or potential future persecutor in harming you, the applicant? Is it because you belong to a political social group and what is the reason? Are you afraid to return? If so, why? Who do you really fear? Who exactly is the persecutor? You should be able to name your persecutor. Is a persecutor a government actor, a governmental actor, or a person or entity that the government is unable or unwilling to control? Is the feared persecution countrywide? Meaning, would it be unreasonable for you to relocate? Because if you can relocate and not face persecution, then that case is likely going to be denied. Okay, you have to be able to show that you cannot relocate reasonably within the country to another part of the country. If you're in the northern part, you are being persecuted. If you move to the southern part, will you be safe? If you're going to be safe, then you shouldn't be filing asylum. You should be able to, because you should be able to let the government know that it's not reasonable for you to relocate, maybe because of some situation or because the persecutors are nationwide and they could still come for you even if you're in the southern part of the country. All right. All right. So yeah, I think that's that. Let me just unshare my screen. Let's see TikTok and Facebook. Please, you feel free to ask your questions and then I can answer them. Now we just have a couple minutes and then we'll be going off. Atoke James says, submitted application for EB2NIW in October, upgraded to premium processing this month. Do you think making this change has a negative impact on my application? Well, I mean, practitioners notice that once you upgrade your petition to premium processing, sometimes it can trigger a request for evidence from the government or trigger some action. Because If you do file premium processing, then it shortens your adjudication to, I believe, 15 days. And the government or USCIS is supposed to take some action. The action they can take on your case can be an RFE, a NOID, or an approval or a denial. So if they don't take action on your case within 15 days, then they have to refund you the money you paid for the premium processing. They don't want to refund that money. The US government, all of this is also, some type of business for them, right? To help them make money. So they don't want to refund the money. So they will take an action, and then that could trigger an RFP, request for evidence, or notice of intent to deny. But if you have a great case, solid, you've explained everything, hopefully that shouldn't. But yeah, that's how that goes. Okay, let's see here. Okay, Sweet Rivera says, on Facebook, she says, does having a visa to Canada have any impact when you want to apply for B1, B2 to the US or F1? Oh yes, that's absolutely that's very helpful. I've recorded a video on this in the past. There are levels of international travel that can impact your ability to get a visa to the United States. The lowest level is being able to travel to neighboring countries. So if you are from Ghana, you can, if you are able to show that you have travel experience. You've gone to Kenya, South Africa, Namibia, Zambia, you've returned to your home country. That's a good indication. Then the middle level of travel is like to Asia, the Dubais and those China. You've come back to your country. That travel experience is very good. Then on top of that, we have travel to Europe. You have the Schengen visa going to Sweden, to the Netherlands, to France, Belgium, Germany. You leave your country, travel for 4 weeks, you return to your home country. That's great experience. They love that. Then the topmost level is obviously coming to Canada or coming to the US in the past. These levels of travels have an impact on your ability to convince a consular officer at the US Embassy that you have ties to your home country that will compel your return at the end of your visit to the United States. So if you've traveled in the past, it's viewed as a positive weighted factor. And that can impact the consular officer's ability to see that, this person is not looking to abscond or run away from her country. She'll come back if she's granted a visa. Sweet Rivera says, you are indeed a good attorney. Thank you very much. She says, please do more of live session at least once a week. We've been doing that. Unfortunately, last week I had an asylum interview, and so we couldn't come live last week. All right, guys, if you don't have any more questions, then I'm going to be hopping off. I'm going to be hopping off soon. Thank you so much for joining us. If you need our help, please give us a call. We'll be very happy to assist you with whatever help you need. Okay, so we discussed a new immigration course memo that will say immigration judges can deny asylum applications. If you are impacted by such a decision by an immigration judge and you are pro se, you went and represented yourself in court, feel free to reach out to us, and then we see how we can work to overturn that decision. Okay, there's ways in which you can fight back and make sure that you get a full and fair evidentiary hearing. You have your day in court. You can get to court and talk about your persecution, the fear and the harm that you face in your home country, and which is why you're applying for asylum. Okay, so again, if you are trying to apply for asylum, in the first place, you just need to make sure that you have a valid claim. If you don't have a valid claim, please don't submit your case. And it's best to work with a qualified U.S. immigration attorney to make sure that what you are submitting makes sense. If you go work with a notario and they just write anything down and submit your application, it takes a lot more money and stress to try to, have some of these things overturned. So do the right thing from the onset to avoid spending more money that when you're trying to go for cheap, sometimes it ends up being a little more costly. So bear that in mind. All right, guys, thank you so much. If you haven't yet followed AK Populo across social media platforms, please do so now. If you've enjoyed the session, type in USA. I want to see USA. Just type it in, or just put the emoji of the US flag. Let me see if I'll find and a question on TikTok. I don't think I answered any question on TikTok. Type in USA as we're waiting to hop off. I don't understand some of the questions I'm reading, so I won't even read them out loud. Looks like some of them are split. All right. Okay, guys, thank you so much. Take care, and I'll see you guys hopefully in our next video. We're going to be trying to, we've been trying to come live every Friday at 1 p.m. EST. So make sure that you're following our social media pages, liking our posts, commenting when you see it, and keep engaging with us. We appreciate you very much. If you enjoyed the session, type in USA, put in the US flag. Let me see that you enjoyed. Okay, I see Instagrammers doing that. TikTok, Facebook, just type that in for us. Follow the page, and hopefully we'll see you in our next video. Take care, guys. Bye. Thank you for watching.